Hello, my name is Rafe McMahon and I'm here with Jessica Goldrick, and together we are the two partners of McMahon Goldrick Solicitors. This firm specialises and indeed very much enjoys representing and assisting clients who have been affected by life-changing, or also known in the legal world to be called catastrophic injuries.
We exclusively specialise in three categories of injury, and those are catastrophic spinal cord injury, catastrophic brain injury and catastrophic birth injury. When we say catastrophic, we mean life-changing for the individual. This video serves as a guide to those who have suffered from a catastrophic injury as a result of an assault.
If you or a loved one of yours has unfortunately suffered from such an injury, and that injury was caused by a criminal assault, then a case may be lodged with the Criminal Injuries Compensation Tribunal with a view to receiving financial compensation. We are now broadly going to take you through some of the steps that are involved in bringing a claim, if indeed you have suffered from a catastrophic injury as a result of a criminal assault.
The injured person is called the claimant, and one of the first things a claimant solicitor will need to do is to obtain an expert report which positively supports the argument that the injury arose as a result of that assault. The speciality of that or those experts will depend on the nature of the injury. Depending on the unique circumstances of your case, you may require a number of expert reports of varying professions before a full medical picture can be established. The claimant's solicitor should lodge the application with the Criminal Injuries Tribunal Board within 3 months, although the board can extend this period. A report should be obtained from the Gardaí, and the tribunal will do likewise.
Broadly, there are three categories of reports that your solicitor will obtain for the purposes of building your case. The first category we already discussed, and they are reports relating to liability and causation. The second category of reports are medical reports. If appropriate, some of these reports may be obtained from your treating doctors, for example your GP, your neurologist, your rehab consultant, among others. These reports are obtained for the purposes of detailing your current condition and your future prognosis from a medical perspective.
The third category of reports is quantum reports. These are the reports which your solicitor will use for the purpose of calculating the bulk of the value of your claim for compensation. Your solicitor will instruct a number of experts to assess your current needs and what your needs will look like moving into the future. Experts under this category can include physiotherapists, occupational therapists, care consultants, housing experts, assistive technology experts, vocational assessors, psychologists, and rehabilitation consultants. These experts will make a number of recommendations to help you live a more independent life moving into the future. For example, the housing expert may advise in relation to the costs of building a home to make it fully accessible. The nursing expert will make recommendations in respect of the number of private care hours that you may require. The occupational therapist will advise in respect of your equipment needs and their associated costs, once again moving into the future. The vocational assessor will ascertain your future loss of earnings. And finally, an actuary will review all of those quantum reports to calculate the total value of those future recommendations.
The costs that have been built up to date will be included in your case. For example, the hours put in by loved ones caring for you will be valued, in addition to your loss of earnings and any monies that you may have put into making adaptations to your home. The solicitors for the tribunal may obtain like-for-like quantum reports, meaning that for every type of expert your solicitor sends you to, the tribunal may arrange for you to see an expert of the same profession for the tribunal. As you can probably tell by now, obtaining the appropriate expert reports are crucial for firstly being successful and secondly for achieving favourable compensation.
Suffering from a catastrophic injury from an assault can be devastating, not only for the person who is injured, but also for that person's loved ones. It is often the case that the injured person was previously the sole or main provider in their home, and they are now suddenly incapacitated and left without an income. Importantly, and aside from the sudden and unexpected financial burden the injury has created, it is often the case that the once independent person is now reliant on their family members for their care needs, and this places both a mental and physical toll on all involved. It is therefore important that you engage solicitors who have a full understanding of the nature of the injuries and the impact that they have, both from the medical side of things and in terms of how they can affect the whole family. Your solicitors must know who the leading experts are and be able to competently instruct them with all of the relevant details so that you can ultimately obtain meaningful compensation to help you live a more independent life.
Your solicitor will hire barristers on your behalf. In a case such as this, you will have a junior barrister and one or even two senior barristers. Your solicitor and barristers will work together as your legal team, and your barristers will advocate for you at the tribunal hearing. The junior barrister prepares some of the legal submissions that may be required by the tribunal. It is crucially important for your solicitor to hire barristers on your behalf who are not only experienced in handling such cases, but also, and this is important, have an in-depth experience of dealing with complex catastrophic injury cases.
The decision of the tribunal is first given in writing, but inevitably this decision is appealed to a divisional sitting of 3 members, at which you and your legal team will attend. There is no need for any expert to be at this hearing. The tribunal, since 1986, may not award you money for pain and suffering, but only for your out-of-pocket expenses, which of course can be huge in such a case. The tribunal does not award costs, so it is important to try and get an estimate from your solicitor as to the possible costs involved. On occasion, the tribunal awards the claimant the cost of his or her expert reports. The tribunal does not settle cases. They will be concerned to know your criminal background, if any, and your involvement in the assault, if any. They can deduct or fail to award compensation depending on that history.
If you have been successful with your case for compensation, then you will receive a lump sum payment. If you have full mental capacity, and if you are over the age of 18 years, you can then spend this money how you see fit. If the claimant is under the age of 18, then the funds are typically lodged in the High Court until that child turns 18. In the meantime, the child's next friend, usually the parent, will be permitted to take out monies to cover the child's expenses and to make big purchases for housing and equipment.
Our clients often use the funds to build a fully accessible home, purchase an accessible car, pay for private care hours and private medical treatments, and purchase equipment to help them live more independent lives, and also to allow them resume old hobbies or even take up new ones. Advice should be secured from a tax expert to ring-fence any monies that are secured in the settlement so that tax is not paid on any income that is generated by investments. We always say that no matter what is recovered, it is never enough for what has occurred, but the lump sum helps to give security and capital to launch a new venture on the back of any confidence that has come with the case being at an end.
Finally, we are now going to go through some of the first steps that you should take if you are considering taking legal action in respect of your injury. One of the first things that you can do is to make contact with your solicitor, who can then advise you on whether or not you might have a case. And they can then crucially start work on lodging your case within the 3-month window and ensure that the evidence is secured and, more importantly, preserved. Another early step that you should take and can take is to write down all of the details that you can recall. This can be particularly difficult, of course, after experiencing such a traumatic event, but it will be of tremendous benefit to your potential new solicitor, and indeed it will assist them with the process. It will also assist them with the process of taking your formal instructions. Crucial details such as what you were doing at the time of the assault, how the assault occurred, who you were with, and what medical services you immediately received should be recorded. The sooner you write these details down, the better.
Another step you can take to possibly speed up the early stages of the investigation is to obtain all of your medical records, radiology, and reports from the hospitals you attended and your GP. Information on how to obtain those records will be available on the hospital's website.
We're now going to talk about how we in McMahon Goldrick Solicitors approach these types of cases. We fully understand that clients who have suffered from such an injury by way of an assault have very specific needs and very specific concerns. We purposely maintain a very low number of files so that individual attention can be given to each client.
We have over 60 years combined experience, and we only deal with catastrophic injuries. So the specialist nature of our office allows us to gently glide over hurdles that others may, with the best will in the world, procrastinate about. Over the years, we have established professional connections with the top medics and expert witnesses who are involved with these types of cases. And our clients are informed in real time of any developments, and they get their case heard as soon as possible, but without taking any shortcuts.
Without ever losing sight of the sensitivity of the injury or the repercussions for the client, we go about our work in that empathetic and honest way, completely aware of how difficult and anxious having a catastrophic injury often is. Clients regularly confide in us and share private matters with us. We respect that. We want to walk in the client's shoes with them. Please, as always, email or telephone us with any queries on a non-committal basis. Thank you for listening.